Why did Judge Glanville, when you did nothing wrong, try to throw you in jail when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why?
Yeah, Judge G did handle y'all like some kids. Big facts.
To anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth.
Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer.
Truth that he has been found to be disqualified and removed from his case for his conduct.
And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay.
What's up, YouTube family, and welcome to the channel. I'm your host, Jay. And man, today we definitely got to take a deep dive into this Young Thug YSL RICO trial. Now, just when we thought things couldn't get any more crazy or more intense with this case, man, the defense comes out with haymakers and bombshells, exposing the state yet again. But this time, in front of the new judge. But before we dig deep and jump into those explosive details, man, tap that notification bell so you'll get the drop whenever we drop on this channel as well. And definitely hit that subscribe. Tap that like button also, whether you're an op or a fan or a supporter of the case or the trial or the state. Hit that like button. You got one thing to do. Without further ado, man, if you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep. So as day 103 of the Young Thug trial kicks off, the latest twist comes in with the new judge being assigned to the case. Coming after the defense filed several motions to have the previous judge, Judge G, actually removed and recused from the case, even asking for dismissal. Now, just when it seemed like the prosecution might finally get a break, the defense has come out swinging. And man, ask yourself this. After watching this, would you say that the state was ready for their case? Or do they seem to be more unprepared than they were when Judge G was actually on stand? So what exactly did the defense do to expose the state? Let's dig.
To anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth that he has been found to be disqualified and removed from his case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
Had said, oh, yeah, we had an in-court, on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Maybe more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there, after finding out about one ex parte meeting and having to drag the truth out, we sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in his ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's is not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on at trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken and it's not okay. I'm trying to raise my voice at you. I'm heated right now.
I can tell.
My head steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay.
So ask yourself, did Judge G actually already rule on this case? Did he already pick a side to favor with the state? Now, we did see his biasness coming off several points and in different pieces of this actual trial. But ask yourself, did he actually go that far to actually rule with the state already in an ongoing case? And with the ex parte meeting, is anybody surprised that the transcripts weren't 100% complete? Now, we were already told that a lot of the actual transcript was going to be redacted, so we already knew it was edited and there were pieces missing. But is that illegal? Is that a fair trial? And does that not compromise Brady information for the state and the judge to actually be withholding information from the defense? Psh, let that sink in. And not to mention, I was wondering yesterday when they kept saying that, hey, the defense has had way more ex parte meetings in the actual state. Why was it our first time hearing that, and why did they add emphasis to it? And the reason being is what the defense is actually exposing right now. The state and the judge definitely been playing foul. Let's dig.
The 24-6-621 is the
Impeachment.
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment just because we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead.
Now, since we've been back, ask yourself, is the state just not prepared for this case? Like they had all the compiled evidence to go from having too much compiled evidence and not knowing what to use to being unprepared? It's got to be embarrassing to the DA's office altogether, and definitely waste of time for the jury, the defendants, and the new judge. Let's dig.
Objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place, because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that it did not go to the holding or the ruling, and she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact.
That the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, "Oh, you seem to want to talk to him, so I will let y'all talk privately," which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by, we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interest, which as a lawyer, you are always supposed to do for your client. So I don't think they meant, literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th.
Now, the defense has been meticulously highlighting the inconsistencies and procedural errors made by the prosecution, not missing one, dotting all I's and crossing all T's. But ask yourself, with this new judge right here in the front of this actual court case, going over this trial, is there any way with all of the errors and the clerical issues and hidden evidence, compiled evidence, is there any way that this case could actually be fair at this point? Now granted, the judge is doing her part. She is here to create that fairness. But if the trial so far hasn't been fair since it's been started, and Judge G actually sided with the state, assisted the state, showed biasness, and was removed due to obligations that he overstepped, how is this case going to actually end fair? And is a mistrial actually fair at this point? Let's dig.
About.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat-out misrepresentation of how.
Okay, well.
So I just want to get the record straight, because now it's, if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding, it's over. The case, no one looks at prejudice. But the two cases that came out in April, that is the law now, but we are interested in whether that is wrong.
Okay.
And we need to show prejudice.
Okay. With regard to,
Like federal.
give me the cases in what?
Step back.
Okay.
So I want to make a record of showing it was prejudicial because they were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well.
And I'm not agreeing.
I'm not sure if I follow you, though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on? But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton, Love, are not true. There's no.
Now, a few of the key points that have been raised by the defense was the misleading information provided by the state to the courts, and also the mishandling of evidence. Now, ask yourself this. Have we been witnessing the state use compiled evidence, mishandling evidence, but evidence being allowed due to the previous judge? Did Judge G already know this? Was this information used to help actually paint that state narrative and paint the picture? Man, this case is sick. And like YSL SCHARDT said, it's actually gross. At this point, when you see that it's basically the defense versus the courts and the actual state, the DA and the prosecutors, that's a lose, 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 lose. But as corruption continues to get exposed, it looks like this new judge is actually starting to see it. And maybe the state's tactics ain't gonna work with her. The Judge G being pulled off the case actually hurt the state. Let that sink in. Let's dig.
True. There's no emails to back up what Love says. Ms. Hilton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties. What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. In the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings. Because
whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday the 10th? Okay.
Hear from him if you want. That did not happen in this. I want to get it right.
All right, so you haven't talked to him yet about what? All right, well, obviously, I'll give you a chance to talk to him before you make a proffer because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Okay. Thank you.
All right.
Now, additionally, the defense has accused the state of failing to disclose critical information, also known as Brady, that could actually exonerate the YSL 6, Young Thug, and his fellow associates. Now, they've argued that this lack of transparency is not only unethical, but it's actually illegal. So if the state is actually acting in good faith, is there any reason that they're using bad practices? Is all this worth a conviction? Is this deeper than rap? Let's dig.
Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands of jail calls involving dozens of people. There are...
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right.
Now that's crazy also. We had to stop right there for the simple fact. Did you see how fast it took Judge Whitaker to catch on to that? She stopped YSL SCHARDT already in the midst of his sentence. Even though she let him finish, she already knew where he was going. Why? Because this is not the first time the state has tried to introduce this type of evidence. It's compiled evidence making the defense actually go in blind. The judge is catching on to it. Interesting, because it actually leads us to our next actual topic, the credibility of the state's key witness. Now, one or two things. Either the state's key witness ain't credible or the state is not credible. Or maybe neither one of them credible. But ask yourself this. Have we seen evidence that may suggest that some of the state's key witnesses are being pressured or coerced to testify against Young Thug and YSL? Absolutely. But ask yourself this. With the new judge here on the trial, she may be here to shed light. But do you think that she sees the play being made by the state? Let's dig.
All right, so I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know how it's supposed to not be trial by ambush anymore? It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? It's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
And so that the court knows what I'm doing, I overheated. And so I had to.
By which you mean your laptop overheated?
I do mean my laptop.
Okay.
And I was
because I've told y'all not to overheat anymore.
So that's what's
okay
happening.
With the new judge now overseeing the case, the defense arguments are being given a fresh hearing for the most part. And so far, it does actually seem like this judge is actually taking these issues very seriously. One thing I do like is how she keeps saying, if we get there, if we make it to that point, if the jury comes back. Maybe she knows something that we don't know, but she's still having to follow her steps to make sure that she dots her I's and cross her T's. Now, with the developments coming off in this trial, the evidence, the lack of uncertainty coming from the state, you can actually say this has certainly shifted the dynamics of this actual trial. The prosecution is now on the defensive, scrambling to address the points raised by Young Thug's legal team and the other YSL defense team. And as always, we're here to definitely keep you updated with every twist and turn. So ask yourself, with the dynamics of this trial actually shifting, does Young Thug actually have a chance? Will these defendants actually be coming home? So ask yourself, have we ever seen the state scramble like this since the start of this case? And ask yourself this, did Judge G already know that the state was potentially losing this case? What does this mean for the future of the case? Would a new judge step in and actually grant the motions from the defense to give mistrials? She's already said she's not giving any bond, so that's already understood. But will we get that mistrial, or will it be a mistrial with prejudice where it can't be retried by the state? Man, I'm your host, Jay. Y'all make sure y'all jump in the comments. Let me know y'all's thoughts. Is the trial seeming like it's starting to go fair now? Or is there any way possible that this trial can actually even be fair at this point? Lil Wood is starting over his whole testimony. Great entertainment from the state, but what a waste of time for everybody else that's participating in this case. Those defendants, especially the jurors. A waste of time, waste of tax dollars. Man, y'all jump in the comments, let me know y'all's thoughts. Was this actually a good day for the defense? And again, how many times can the state continue to be exposed, from AB to the YSL defense, to the evidence, to Judge G? Now Judge G gone, new judge in place. Man, come on. You think the jury ain't paying attention to the state's play? Man, until next time, remember, the life you save might be your own. Until next time, jump in the comments, hit that like button, subscribe to the channel. And remember, it's your boy Jay. Gone.